Good here.
Hello, and welcome to this installment of the Pro Bono Partnership of Atlanta's webcast series. I'm Sarisha Gunta, Education Director with PBPA. Today, we will be talking about real estate, and more specifically, legal considerations for nonprofits that may buy or accept a donation of contaminated property. I'm excited to have Scott Lassiter, Jack Devine, and Andrew Haygood from the law firm of Kasmerick, Mowry, Cloud, Lassiter to share their insight and expertise with us today. Before they get into the substance of today's presentation, I would like to share a bit about our mission at the Pro Bono Partnership of Atlanta. PBPA provides free business legal services to Atlanta area nonprofits. We connect small community-based nonprofits with volunteer attorneys from law firms and corporations. PBPA strives to provide legal insight relevant to small Georgia nonprofits, striving to meet nonprofits where they are in their journey and capacity. Our Learning Center has curated podcasts, webcasts, and articles, and these are available to anyone for free and are tailored specifically to small Georgia nonprofits. If you have a legal question, you can probably find an answer there. And for organizations that are interested in receiving direct services, our clients are 501c3 organizations that are located in or serve the greater Atlanta area. Our clients serve low-income or disadvantaged individuals, and the organizations are otherwise unable to afford legal services. If you employ at least one paid staff person and you are interested in applying to be a client, you can use this link here for more information and to apply. And now a little bit of housekeeping. This webcast is copyrighted. We welcome your general questions during the presentation, but keep in mind this is just general information. It's not legal advice. Please reach out directly to an attorney if you need to discuss specific concerns. And for general questions on today's topic, please use the Q&A to pose your questions to Scott, Jack, and Andrew. We have a lot to cover today, but we do strive to answer all questions by the end of the program. I will share the slides in the chat momentarily. Plus, this is being recorded, so the slides and recording will be available on our website next week. Now, I'd like to share a bit about our fantastic speakers. Andrew Haygood is an associate at KMCL, where he advises clients on environmental law matters, including land conservation and litigation. Jack Devine is also an associate at KMCL, where he counsels clients on complex regulatory compliance, permitting, and environmental litigation matters. And Scott Lassiter is a founding partner at KMCL, where his practice encompasses litigation, regulatory compliance, and transactional matters for clients ranging from publicly traded companies to nonprofits. Scott, Jack, and Andrew, thanks so much for being here to speak to our nonprofits about the risks and rewards of environmentally challenged properties. I'll hand the mic over to y'all.
Thanks, Sharisha. I'll kick us off by saying just a few more words about what KMCL is, and then sort of painting the outline for the rest of the presentation. So KMCL is an all-environmental law firm. We now have 22 full-time environmental lawyers, which many people would say, wow, I had no idea there was enough environmental work for that many people to be doing, but we are staying very busy. An important part of something we have done for decades now is to do what we call a contaminated property or hazardous sites practice, which involves the buying, the selling, the investigating, the cleaning up, or the fighting over property that's been somehow impacted by an environmental problem. We are primarily a for-profit law firm, but we've also over the years represented a number of nonprofits, some of which we'll be able to tell you a little bit more about later on. Um, I'm going to give a sort of very, very high altitude flyover of some of the basic framework of the legal environment that affects environmental issues, especially for how nonprofits might encounter them. And then we're going to turn and actually try to go through a series of examples. And we hope at the end that you'll have some sense of what is actually possible when it comes to dealing with environmental issues affecting real estate for nonprofits. So if I can roll to that first slide, um, is a stage setting matter. It's important to realize that environmental questions are only a small part of a bigger series of questions that nonprofits have to go through whenever they consider acquiring property. And I should say that property can come to a nonprofit through several different pathways. The maybe most obvious pathway is when the nonprofit itself decides that for its mission, it needs to acquire a piece of real estate and wants to own it. But it can also show up because donors or other third parties present an opportunity to the nonprofit to say, hey, you could take advantage of this piece of property. And even in some cases, a donor will want to donate an appreciated piece of real estate merely with the expectation that the nonprofit might liquidate it for its cash value. um, all those um, all those different ways in which real estate might come to a nonprofit implicate the same series of questions, which is that the nonprofit needs to think through very hardly, does it have an actual use for the property? Is there really room in the nonprofit's budget for the actual cash, not only to acquire the property, but for the associated cost of managing it? And also, one needs to think of the budget not only in terms of money, but the budget in terms of sort of bandwidth or just institutional ability to take on um, the extra burdens of being a property owner. That's something the organization needs to evaluate. It also needs to evaluate what you might think of as reputational considerations, reputational concerns. Those can be related to environmental issues. In other words, is there either a plus or a minus for a nonprofit to be associated with an environmental story? But it's also outside of the environmental world as well. If you are an owner of real estate, in some ways, the collateral activities around that piece of real estate, it will inevitably have some impact on the reputation of the organization. Those are all things that you need to figure out in advance of reaching that point of saying, yeah, I want to go forward and really look into a particular piece of property. If the decision is made, yes, we want to go on to that next stage, then the next stage is going to be due diligence. Environmental is going to be one piece of that effort, but only one piece. It's important to emphasize that. Let me ask you to advance the slide. So I'm going to pivot now from talking about the big picture of how real estate might present itself to a nonprofit to talk about the basic regulatory framework for environmental problems as they relate to real estate. Modern environmental law, as it relates to contaminated property, dates back to 1980 in the enactment of a law that we call CERCLA, which stands for the Comprehensive Environmental Response, Compensation, and Liability Act. Big mouthful. Its shorthand name is Superfund. That law at the federal level was created in response to a rather scandalous occurrence where a neighborhood known as Love Canal in upstate New York was discovered to have been built on top of a hazardous waste dump. And there were pictures in the newspaper of literally drums coming out from underneath people's houses, and there was a real outcry for how can that happen. So Congress raced forward and created this very comprehensive regulatory scheme at the federal level to govern these sorts of sites. That was the origin of the joint and several liability concept for environmental problems. That anybody who knows anything about environmental law, that's usually the first thing they have in mind is, wow, you can be jointly and severally liable. that created at least a theoretical possibility that a person who's found to be within the class of liable parties, even if they have just the teensiest connection to the problem, can end up being theoretically responsible for cleaning up the entire thing, theoretically responsible for millions upon millions of dollars. Um, it's important to realize or recognize that although that's a theoretical possibility, and that possibility definitely got the attention of the real estate industry, and really changed the way everybody thinks about environmental law, and in fact sent many people screaming into the night in horror. The reality is that that's a very rare set of circumstances. That generally speaking, the concept behind Superfund and even state level environmental laws is a polluter pay concept. So the idea of someone who has remote connections to liability ending up being terribly responsible is an exceedingly rare outcome. So Georgia followed the federal program by about 10 years. So in the early 1990s, Georgia created what we call a mini Superfund law, which is the Hazardous Site Response Act. That law largely governs both the classes of chemicals that are concerned in that federal Superfund law and also the basic liability scheme under HISRA is essentially the same as that federal program. Because we're in America and we have lobbyists, when they created the Superfund law, the petroleum industry was at the table, and the petroleum industry managed to get a separate set of laws created to govern petroleum-related underground storage tanks. So although most types of contamination that might be in the ground are covered by Superfund, and therefore by our Georgia HISRA, if it's a petroleum product coming out of an underground storage tank, it's regulated by a separate program known as the Underground Storage Tank Program. It has a slightly different liability scheme that could be important if it's an underground storage tank that's actually the problem at issue. The third major Georgia law out there is known as the Georgia Brownfield Act or the Georgia Brownfield Program. This is really important for nonprofits. The Georgia Brownfield Program creates a pathway by which any innocent party coming to a property, meaning a new buyer of property or even a new tenant or other new user of property, can, in exchange for doing a limited amount of investigation and cleanup, enough to make sure that the property is safe, can get liability protection from all that scary stuff that we were just talking about. So the Georgia Brownfield Program is really key to the pathway for nonprofits to be able to take on environmentally challenged properties. And we'll talk about some examples of that in a minute. The last one I'll mention is the voluntary remediation program. If you get into the world of dealing with a contaminated property, it is also possible that it might go through the voluntary remediation program, or VRP as we call it. Significantly, it does provide a pathway to regulatory closure, but it does not have liability protection. So if you are a new party, like a nonprofit acquiring a new property, you're going to be wanting to look to the Brownfield program, not exclusively to the VRP. Let's take a look at the next slide. There are a whole bunch of classes of liable parties, but I want to boil this down because this makes it a little bit less scary. From a nonprofit organization standpoint, in 99 and 9/10, maybe even you can roll that decimal point out even farther, of the cases, the only two types of parties that matter are the current owner of the property, and that's the current owner of property impacted by some kind of hazardous substance that's regulated by that Superfund law or by Georgia's mini Superfund law, or the other is the owner or operator of the underground storage tanks themselves, if we're dealing about contamination coming from an underground storage tank. Those two classes are very closely related, but they're different. So if this is a site that falls in the class of sites for which the federal Superfund and the state mini Superfund apply, the first category matters. In other words, it's just who owns the property. But if this is an underground storage tank problem, such as something from a gas station or other places where you have underground storage tanks, the class of liable parties is not the owner of the real estate, but the person who owned those tanks. Very important distinction. And often that's all it takes to be able to say, wait a minute, a new party buying this piece of property may not actually have direct liability at all. All the other classes of liability, which include things like the people who transport the contamination and the people who dumped it in the first place, those almost never matter for nonprofits. We won't spend any time on that. We can roll on to the next slide. So, as I've mentioned, the main class of liable parties that we're worrying about is if you own the property. Obviously, if you're going to buy a piece of property as a nonprofit or have a piece of property given to you as a nonprofit, you're going to be in that class of liable parties. The Brownfield program gives you a way to get out of the class of liable parties, or said better, to have a statutory protection against liability in exchange for doing a certain amount of investigation and cleanup. So the real key is how much will it cost? As I suggested earlier, the environmental industry has now been doing this for several decades. We know how to clean up almost any amount of property. In fact, there were people swimming in the Chicago River last week. So no matter how bad it is, for enough money, you can clean it up. But the question becomes, can you clean it up and can you make it safe for an amount of money that makes sense within the transaction that we're talking about? And this goes back to the original sort of thought process about whether you're going to acquire the property. Part of the question is that cost significantly less than the property's worth? A secondary question is, are those costs worth it from a cost benefit standpoint? It may well be that there's net value to be had, but it could be that this just proves to be too hard. So those are the key questions that due diligence is going to attempt to answer. Let's roll forward to the next slide. And with that, I'm going to turn it over to my colleagues, Jack and Andrew, and we're actually going to walk through some very specific sites here in Atlanta where nonprofits, hopefully just like you, have had great success taking environmentally challenged properties and making something really beautiful with them.
Before we go to the examples, I have a quick question about liability. If a nonprofit were to enter into an agreement where they purchase this property, just can you clarify who could they be liable to? Who could bring suit? Is it the government or people who visit the property and get sick?
Yeah, the list of people who theoretically could bring a claim is quite long and quite scary. It starts with the federal and state governments who, under these statutes, have a claim. It then extends to anybody else who has spent money responding to this problem. And then it goes even further to include neighboring property owners, or as you suggest, even individuals who claim to be injured in some fashion by the contamination. Again, fortunately, the Brownfield liability protection in that statute protects you against all those classes of parties, all those classes of particular claimants.
Thank you.
Thank you, Scott, for setting the stage there. And as Scott said, Andrew and I will now go back and forth, giving you specific examples of brownfield redevelopment and nonprofits. So the first one we're going to look at is the Atlanta Humane Society's newer adoption center, and the address is 1551 Perry Boulevard Northwest. You can go to the next slide. Thanks. So immediately prior to this redevelopment effort, the address was associated with an active scrap metal operation, which, as you might assume, had some environmental impacts associated with it. A 2012 Phase 1 environmental site assessment flagged potential issues related to underground storage tanks, or you'll hear people say USTs a lot for that, suspect fill material, and nearby reported releases. Some follow-up sampling was done about 5 years later in 2017 through 2019, and that confirmed metals in both the soil and groundwater. They found evidence of silver, lead, mercury, barium, and chromium. All of those together drove the need for excavation and for the implementation of a vapor mitigation system beneath what would become the new building. The Atlanta Humane Society purchased the property in 2020 and entered into the Georgia Brownfield program, which eventually culminated in the issuance of a limitation of liability in 2023 once all the remediation work was done. That work included 6 excavation areas with regulated offsite disposal, which basically means that those materials had to go to a specific landfill license to accept materials like that. And they removed more than 1,000 tons of impacted soil. Post-remediation confirmation demonstrated compliance with non-residential risk reduction standards, which basically means that in order to get approval through the brownfield program, you have to get contamination levels below certain levels depending on what you want to use the property for. And so if you wanted to redevelop something into a residential property, then those levels are much more stringent. The completed facility here provides adoption and veterinarian services on Perry Boulevard, and it is known as the Arthur N. Blank Family Animal Center. We can move on to the next site. That's all I have for the Humane Society.
So the next site that we're going to talk about is the new Trees Atlanta headquarters, which is located at 825 Warner Street Southwest. And this is a photo of what the headquarters looks like now. If you can go to the next slide, please. Thank you. So this property historically had been developed with 2 buildings in the Oakland City neighborhood, which is near a deer park in Southwest Atlanta. And those structures dated back to around 1950. They were originally used for a steelworking company and then a series of other businesses, including some produce and meat companies, a commercial bakery, and then an artist studio. Then Trees Atlanta became interested in the site, and they commissioned a phase 2 environmental site assessment, which showed that the site was contaminated with lead above the regulatory threshold levels. So Trees Atlanta then submitted a proposal to outline what it would do to remediate the site in 2019, and then purchased the site and began to engage in those remediation activities. So just like the Humane Society, they ended up excavating more than 1,000 tons of soil initially. And then as they began to prepare the site for Trees Atlanta's use and to begin construction on the buildings on the site, they uncovered more soil that seemed to be contaminated. They tested that soil and confirmed that it was indeed contaminated. So then they removed an additional 337 tons of soil. After doing that, they did post-remediation sampling and found that the soil was now in compliance with the non-residential risk reduction standards that Jack mentioned. So Trees Atlanta then built its headquarters and implementation center on the site and converted more than half of the site to natural landscape with 200 new trees and thousands of native plants. And they've actually opened those green spaces on the property up to the public in the neighborhood. And I'll turn it back over to Jack for the next slide.
So next, we're going to cover the Life Cycle Building Center, which is 1116 Murphy Avenue Southwest. The property comprises 2 early 20th century industrial buildings in the Murphy Triangle area. In total, it's about 70,000 square feet on roughly 3.5 acres or so. The buildings used to be a foundry and a sprocket manufacturing facility. In 2016, Life Cycle Building Center moved from a tenant to being an owner of the property in an effort to align stewardship, cleanup, and redevelopment under one banner. The Life Cycle Building Center submitted a PP CAP in 2016, a prospective purchaser corrective action plan, and Georgia EPD then issued an approval letter for that in September of 2016, formally enrolling the site in the Brownfield program. In addition to the state Brownfield program, EPA Region 4 awarded a brownfield cleanup grant of around $200,000 with a $40,000 cost share, and the EPA work plan was finalized in 2018. Cleanup here was scheduled for February through June 2019 and focused largely on indoor air quality improvements via asbestos and lead-based paint abatement, plus targeted soil remediation to achieve Type 3 risk reduction standards. Nova and Titan Environmental Services were listed as the contractors, and both have write-ups on their web pages about this work also. Public engagement included meeting notices in 2018 and 2019 and a posted request for proposals for remediation services, providing a transparent nonprofit procurement model. A warehouse renovation phase moved forward in 2021, demonstrating how phased capital upgrades can dovetail with brownfield implementation. Move to the next slide.
So the next property we're going to talk about is the Mary Leela Lofts facility. These pictures are the outside of the facility as it looks today, and then an example of one of the units inside the property. This property is a little further outside of Atlanta. It's over in Greensboro. And it was initially used as a cotton mill until 1971, and then it was purchased by another milling company to manufacture ropes and cords. That company, the property was foreclosed on in 2005 and then purchased by a historical mill restoration company. After that company purchased the property, the city of Greensboro applied for grant funding from EPA to do environmental assessments of brownfields in the area and used $115,000 of that funding to perform these phase 1 and phase 2 investigations mentioned on the slides. The phase 1 investigation identified where former underground storage tanks were located. And based on that discovery, the Historic Mill Restoration Company sought coverage under the Brownfields program. They excavated the contaminated soil near the former USTs and then wrapped up that initial process. Then 8 years later, in 2013, phase 2, more intensive environmental site assessment was conducted, and that showed that the soil was still contaminated by metals and semi-volatile organic compounds above the residential risk reduction standards. So after that phase 2, the company Greensboro Mill LP, which is a nonprofit that sought to convert the mill buildings into affordable housing, purchased the property. They submitted a corrective action plan in 2017, which EPD approved, and they then removed 2,600 tons of soil from the site. They did, instead of removing all of the contaminated soil, they used some asphalt and concrete as engineering controls on portions of the property to reduce the costs associated with excavating that much soil. They then, after that was completed, converted the property into 71 affordable housing units that have 1 to 3 bedrooms and included community amenities like the playground on the previous slide, a fitness center, and a community gathering space. After that renovation process, residents moved in, and some of the residents even include former mill employees. And in 2018, the site received awards from the Georgia Trust for Historic Preservation based on its efforts to balance creating affordable housing and preserving this important historic resource. Turn it back to Jack.
So the last site I'm going to talk about is the East Decatur Greenway, which involved converting a former gas station at 890 Columbia Drive into a public trailhead and green space. As you might imagine, gas stations often set off alarm bells, which makes sense given what they involve. And here, historic operations of this gas station included 3 8,000-gallon USTs and 2 dispenser islands. In addition to that, there was a 1997 release reported to EPD. And as a result of that, by around 2012, the tanks, dispensers, 75 linear feet of piping, and approximately 318 cubic yards of contaminated soil were removed. In 2015, a final corrective action plan cleanup activity included complete demolition of the former station, targeted excavation and offsite disposal of impacted soils, backfilling with clean material, and stormwater quality upgrades such as a rain garden feature. One excavation intersected the 75-foot stream buffer along the East Branch Middle Fork of Shoal Creek, requiring a DeKalb County stream buffer variance as part of the implementation. I included that just because it's interesting to consider how there are other factors that go into these redevelopment activities beyond just the remediation goals themselves. Funding here included an EPA petroleum cleanup grant, which was awarded in 2014 with supplemental funding in 2017 to complete petroleum impact remediation. Georgia EPD recorded cleanup complete on December 4th, 2017 at a non-residential type 3 risk reduction standard with some use restrictions. East Decatur Greenway notes that by 2018, all Georgia EPD and US EPA requirements were fulfilled after the installation of the rain garden system, and that the site now serves as a landscape trailhead directly across from the Friends School in Decatur. It also it anchors the neighborhood side of the Greenway connection to the Avondale MARTA station.
And the last site that I'll be talking about is one piece of what is now the Paul Avenue Park. The specific parcel we're talking about is the address is 0 Paul Avenue Northwest. This site was historically undeveloped, so there hadn't actually been industrial activities like all the other sites we've discussed. However, at some point prior to 1995, some unknown entity dumped contaminated fill material from an industrial facility located elsewhere on this property. This was discovered in 1995, and then soil samples were collected showing a variety of different metals contaminating the soil at the property. Georgia Power owned some adjacent property, and so they conducted the initial cleanup of this property in 2006. Then fast forward roughly 13 years later, the Conservation Fund, a nonprofit, was planning to develop this whole strip of property along the Chattahoochee into the Paul Avenue Park. And as part of that, they conducted a phase 2 environmental site assessment of this parcel because they knew there had been that previous contamination. The phase 2 showed that there was lead and chromium contamination still in the soil. And so based on that, the Conservation Fund submitted a prospective purchaser corrective action plan to EPD, which EPD approved. The Conservation Fund started remediating the property in 2021, again by excavating and removing 744 tons of contaminated soil. So after that, they sampled the soil again, and results showed that the remediation was successful. The site now serves as part of the 10-acre park that's being developed by the Conservation Fund, which includes a river walk along the Chattahoochee River. And the Conservation Fund is still continuing to develop the park, planning to add additional facilities in the near future.
I have a quick question, maybe it's not a quick question, about why do you think that these organizations, and these are all great examples and they cover such a wide range of situations, but generally speaking, why do you think these organizations decided to move forward with these acquisitions, given that these steps would be needed down the road in order for them to be able to use the property?
Yeah, it's a great question and not a short one, but I'll try to sort of summarize that process. And it goes back to some of the earlier conversation that we were having. The combination of an environmental issue and a location may create an opportunity for a nonprofit that doesn't exist anywhere else. For many properties, and you can think about the adoption center that we saw from the Atlanta Humane Society, it's very difficult to get a large enough facility in the location where you actually want to meet your clientele and do it at an affordable price. So when the opportunity in that situation came along to in essence buy property well below market in exchange for taking on some of this environmental work, the deal made sense. It made sense to spend those extra dollars because they were still ending up with very, very good value. There are other situations, and you can think of the Trees Atlanta site as being a great example where part of the mission of Trees Atlanta is in fact to try to bring trees into the urban area. So it would be real easy for Trees Atlanta to go out into the suburbs in what we call a greenfield setting and find a nice pristine property. But by bringing it inside, that location is right off Memorial Drive in a very urban area. That is in itself part of the mission. So all those things combined, but fundamentally, the equation has to balance. It has to end up being a situation where the nonprofit has the capacity, both financial and sort of in bandwidth, to take it on. It has to make economic sense in the sense the cost of the property combined with the cost of the remediation makes sense, and it has to work from a mission standpoint. So all three of those things have to come together, and they don't always come together. And on closer evaluation, we often end up finding the right answer is sometimes no, but sometimes it's yes, and when it's yes, there's some really great stuff. Jack, did you see the question about the Paul Avenue? Or is that Andrew? Did you do Paul Avenue?
Yeah, I did Paul Avenue. Let me
Yeah.
read the question.
Yeah.
So yeah, my understanding is that the prior dumping was actually reported by a neighbor across the street from the site, which is what prompted that initial, I think it was 1995 sampling. And then when the Conservation Fund was thinking about purchasing that parcel of property, because they knew there had been that prior contamination, my understanding is that they wanted to sample again just to make sure that it had been properly remediated. And of course, the sampling showed that it hadn't been fully remediated, which is why they excavated that additional soil.
And I'll take a moment to add on to that. Just sort of basically, when environmental professionals do environmental due diligence, you're engaging in three essential tasks. One essential task is to examine the historical use of the property. That's often through aerial photographs, interviews with neighbors, like in this case, who might have actually been aware of something that would have happened out there, and other historical sources. The second thing is to do a regulatory agency or database review to go down to the various agencies that might have oversight over a facility and look for records that might affect that property. And then the third thing is to actually go put boots on the ground, to go walk the property, walk the area around the property, and look for indications. My strong hunch is that all three of those avenues probably pointed to something being a little bit funny on this piece of property. There was likely in some historical photographs some evidence that, hey, there's been land disturbance here that doesn't make sense on an otherwise undeveloped property. There were likely some regulatory files, and the conversations with neighbors likely pointed in the direction. And I suspect by walking around the property, there was probably evidence of the dumping too. So all those things come together, and it's all why due diligence is so important. So we could flip to the final slide in our presentation. We were privileged to join the PDPA for a podcast a few weeks ago, talking about acquisition of real estate for nonprofits. And that podcast touched on environmental, but it also touched on real estate and other disciplines as well. Out of that podcast came a checklist for nonprofits considering acquiring real estate. We would commend that checklist to your closer review if you get serious about looking at a piece of property. There's a link here to the podcast itself, and Sarisha, I'm pretty sure that you can find this checklist somewhere on PBPA's website. As a concluding observation I'll make, if you look at this outline, you will notice that environmental does not show up until we're down in item 4, part C. That's evidence of the fact that although environmental is important, it's only a small piece of the puzzle. It's really, really important to not let the environmental tail wag the dog. And that means not to let the environmental questions get you to a false no, or to let you go to a false yes. It just has to fit into a much bigger piece of it's a piece in a much bigger puzzle. We have a moment left for questions, or we can wrap it up there.
Yeah, we do have some questions that came in actually with pre-registration, and so I'll share those now. One nonprofit is asking, what resources are available for nonprofit organizations that find out they are renting and operating on a brownfield site?
Great question. PBPA is one such resource. That a real question. It may well be that there are no adverse consequences to being a tenant in a brownfield property. You don't know the answer to that, but it's quite possible that everything's fine. But a first step, I think, would be to try to get an environmental professional, either an environmental lawyer or an environmental consultant, to do a basic evaluation of whether or not this site has reached regulatory closure and if there's anything else necessary. If the site has reached regulatory closure, for example, through the brownfield program, it's quite possible that the nonprofit tenant is already protected by that limitation of liability we've discussed.
Okay. Thank you for that answer. That is all the questions that we have right now. Oh, I see one more. Just one second. We have a question about the acquisition. At what point in the acquisition process does the environmental evaluation come in, and who is responsible for the initial cost?
So I'll take those in reverse order because all the costs related to acquiring a piece of property are subject to negotiation. Everything from the amount of money and who pays for the purchase to the closing cost to the title insurance to the environmental assessment. So all of those things are capable of being negotiated as part of a transaction. And that then leads to the first part of the question. The time to be considering all of those things, including environmental due diligence and the other aspects of the transaction, are actually before you've reached an agreement to acquire the property. Because ideally, those are all things that you would understand enough about to negotiate as part of the deal.
Great. That looks like all the questions for today. Thank you so much to our viewers for tuning in. There will be a survey that pops up when you close out, so please do share your feedback. We really do value that. And Jack, Andrew, Scott, thank you so much for sharing your time and expertise with us today.
Our pleasure.
Thank you.